husband petition, my lord, challenging the orders of the trial court, wherein, my lord, an application filed by the husband, who is the petition before the trial court, is dismissed. The application, my lord, sought for a direction to the respondent to undergo for a medical test, proving herself that she is an impotent. Because, my lord, the petition is filed under section 12 of 1, saying that, my lord, she is an impotent. The decree of the allowed, that is not allowed. The original petition is filed before the trial court. For the husband, my lord. Yes. He filed a petition under section 12(1), my lord. Yes. Seeking for a decree of, my lord, nullity of marriage. On the ground that, my lord, the respondent is an impotent. During the pendency of the proceedings, my lord, he filed an application seeking for a direction, direct the wife, respondent, to undergo for a medical test to prove that, my lord, she is capable to get married. That was came to be rejected, my lord. How this memo is moved? What is the urgency for that? My lord, he, my lord, got married in the year of 2015. Matter, my lord, was laid before the trial court for 9 years. She has filed, my lord, against me a domestic violence. She has also prosecuted me under 498. You also filed this petition of 2023. My lord, the application itself is rejected in the, my lord, 2023. We will pass orders. Please come to the order. Lordship may kindly see. Yes. Now that you will say that she is impotent, please, and you will send her to the medical test, and basing on that medical test, you will prove. Please, yes. Please come to the order. Lordship may kindly see. The petitioner, my lord, is an husband. Order impugned. Where is it? Please, my lord. Order, my lord, impugned. Annexure E, my lord, 2/2023, page number 55 to 71, my lord. 71. The finding, my lord, is, my lord, available in page number 70, para number 15, my lord. Only one para, my lord, that is the finding. What is the date of marriage? Date of marriage, my lord, 11/6/2015, my lord. When did you file this MC? 5/8/2016, my lord. Matter may be considered from another angle. In all such matrimonial cases where divorce is sought, say on the ground of impotency, schizophrenia, etc., normally without there being any medical examination, it would be difficult to arrive at a conclusion as to whether the allegation made by a spouse against the other spouse seeking divorce on such a ground is correct or not. In order to substantiate such allegation, the petitioner would always insist on medical examination. If the respondent avoids such medical examination on the ground that it violates his or her right to privacy, or for that matter, right to personal liberty as enshrined under Article 21 of the Constitution of India, then it may in most of such cases become impossible to arrive at a conclusion. It may render the very grounds on which divorce is permissible negatory. Therefore, when there is no right to privacy specifically conferred by Article 21 of the Constitution of India, and with extensive interpretation of the phrase personal liberty, is relating to Article 21, it cannot be treated as an absolute right. What is emphasized is that some limitations on the right have to be imposed, and particularly where two competing interests clash in matters of the aforesaid nature, where the legislature has conferred a right upon his spouse to seek divorce on such grounds. Please come to para 78. 78, Lord. It is, however, axiomatic that a court shall not order a roving inquiry. It must have sufficient material before it to enable it to exercise its discretion. Exercise of such discretion would be subject to the supervisory jurisdiction of the High Court in terms of Section 115 of the Code of Civil Procedure and Article 227 of the Constitution of India. Abuse of the discretionary power at the hands of a court is not expected. The court must arrive at a finding that the applicant has established a strong prima facie case before passing such an order. In this matter, there is no cohabitation at all. Since from the beginning, the respondent not even allowed to take the respondent. The petitioner not even touched her. There is no ceremony. Even the ceremony is conducted, she was refused. Yes. Since from the beginning, the entire pleadings of the petition is very clear. That is the reason, my lord. That is the reason the petition, my lord, instituted for seeking for a decree of nullity for not divorce. Understood? Yes, next. Next para. Next para, my lord. Palani Swami. 79. Judgment. I've read the judgment. Next. I may request 70. The next para, my lord. The next para.
Yes.
At the very same level. If despite an order passed by the court, a person refuses to submit himself to such medical examination, a strong case for drawing an adverse inference would be made out. Section 114 of Indian Evidence Act also enables a court.
First says you should make out a prima facie case.
Please, Palak.
Court should be satisfied.
Please, Palak.
Exercising the jurisdiction of 115 or 227 that you have made out a case.
Please, Palak.
Then the court will order for that. If the other person refuses it, then the question of adverse inference. So now the whole question is, have you passed on those steps?
Please,
The question, at what time you filed this application?
This application is being filed.
Yes, you file your case and immediately you file an application. Is it a case that there is you have already made out a prima facie case?
Lord, when a petition is being filed under Section 12, my Lord, for seeking for nullity of marriage, my Lord, unless there is a medical evidence, my Lord, I can't prove my Lord she is important. Because my Lord, it is an arranged marriage. She is also a stranger. Well, marriage has taken place in the year of 2015 itself.
Yes.
There is no cohabitation at all between the parties. My Lord, how, my Lord, under what material, my Lord, what can expect me to produce, my Lord, before the court to demonstrate that, my Lord, she is important or not important, my Lord. Only, my Lord, by way of medical evidence, it can be, my Lord, examined.
Yes.
Next matter, my Lord.
Palani Swami, which para?
My Lord, this Palani Swami judgment, my Lord, I have produced only for the reason, my Lord, before the trial court, they have, my Lord, raised an objection, saying that, my Lord, there is no provision, my Lord, seeking for a medical examination. And there is an error in the provision. That is the only reason, my Lord, I have produced that, my Lord. Even the error, my Lord, can be neglected. That is the only reason.
Yes. Next judgment.
Next judgment, my Lord.
Zahida
Begum. Para number 3, 4 and 5, my Lord. Married, my Lord?
Yes.
Page number 48, running page 48, my Lord. Yes. I have been taken through the impugned order with the assistance of the learned counsel appearing for the petitioner. It is no doubt true that directing either of the parties to undergo medical test in the circumstances is certainly warranted. The question is whether the defendant should be subjected to medical test or the plaintiff also should be subjected to identical test. It is to be noted that the specific case made out by the plaintiff petitioner is that the marriage could not be consummated as the defendant respondent was impotent and he was unable to perform the matrimonial obligations in the circumstances. The question whether the plaintiff petitioner is virgin or is not wholly unnecessary. In the circumstances, the learned trial judge would not have directed the plaintiff petitioner to undergo virginity test at the hands of the so-and-so. The question whether right of privacy is invaded in the matrimonial case where the parties are subjected to medical test.
Those judgments are referred to in this. The earlier judgments are referred to. Sharada's case and all.
Even in the order it has been reflected. All the judgments have been
in this judgment.
Para number 5 is very clear in this order. The order directing the defendant respondent to undergo medical test at the hands of the heads of so-and-so Kim's Hubli regarding potency is maintained. The order directing plaintiff petitioner to undergo virginity test is on so-and-so is set aside. Well, it is permissible.
Yes.
Next, my Lord. Shivadayal.
Not Shivadaya. Next is Madhya Pradesh High Court judgment.
Please, my Lord. Shivadaya. Oh, sorry, I'm sorry, my Lord. Even Shantabai, my Lord. That is, my Lord, running page number 53, para number 6, my Lord. On the bottom, last 2 lines.
Yes.
Whether it is found that after a reasonable time of marriage, there could be no copulation in spite of opportunity.
Are you reading para 6 or para 8?
6, my Lord.
It starts with Srimati Shanti Bai.
And the last 2 lines, my Lord.
After 1 month, she went back to her matrimonial home.
The basis on which, that is para number 5, my Lord.
Para number?
That is in para number 10, out of that, point number 6 in the last line. 53, last 2 lines.
The finding is at para number 11.
Please, my Lord.
Applying these tests to the present case.
Before that, my Lord, I would like to read, my Lord, that point number 6 in page number 53, bottom of the 2 lines, right side corner. Last, my Lord, 6 in bracket. Running page number 53, my Lord. On the bottom right side, last 2 lines. Married, my Lord. Whether it is found that after a reasonable time of marriage, there could be no copulation in spite of opportunities because the other party refused to intercourse and resisted all attempts by the husband without just cause, the court would be right to conclude that the refusal arose from the incapacity to consummate the marriage
I'm not able to find where are you reading. Are you reading this judgment of Madhya Pradesh AR 1966?
Please,
Madhya
Malad.
Pradesh.
Please, Malad. That is, Malad.
Paras are very clear. Why this confusion?
Malad, para number 10, Malad. Page number 12. 53. 10.
Legal position on impotency.
The two legal position impotency is in the very same para, last bottom second line from the bottom.
Whether it is found that after reasonable.
Yes. Please, Malad.
Whether it is say 6 in 10.10, the para number 10.
Point number 6 in para number 10, Malad.
Yes.
Whether it is found that after a reasonable time of marriage, there could be no capitulation in spite of opportunities because the other party refused to interpose and resisted all attempts by the husband without just cause, the court would be right to conclude that the refusal arose from the incapacity to consummate the marriage. Applying these 11, my lord, I'm reading 11.
Yes.
Applying these tests to the present case, in having given our anxious consideration to all the facts and circumstances, we have come to the conclusion that although the appellant is not structurally or psychologically incapable of allowing sexual intercourse generally, yet she has an uncontrollable aversion to allowing the courts to the petition husband. This case belongs to a rare variety of frigidity, quad hang, and we further find that such unconquerable aversion to the consummation of marriage existed at the time of marriage and has been in existence continuously. We are satisfied that these proceedings have been free from collusion. The parties appear to be before us.
So once you have a judgment of the apex court, then why do you want to rely on the judgments?
Please, my lord.
Yes.
All the judgments are following the very same, my lord. My respectful submission before this court is my lord. My lord, she was with me for very particular period of very short period. My lord, she never allowed me to touch her. And my lord, there is no cohabitation between the parties, my lord, according to me in my petition aversion. But when such being the case, my lord, the husband cannot be expected to demonstrate or produce any document, prima facie document before the court to show that, my lord, she is impotent. Unless, my lord, there is a medical examination, my lord, by way of, my lord, order of the court. My lord, I can't demonstrate before the court. That is my grievance, my lord.
But the petition has been filed on 4/1/2016, man.
4/1/2016. You said 5/8/2016?
4/1/2016 was the date when
that is after 6 months of marriage.
So they had issued a notice to me on 26/12/2015.
26/12/2015.
Within 8 to 9 days, they filed the petition without even waiting for my reply to reply the notice. They filed the petition. Subsequently, the first week of January 2016, I filed the reply notice. We issued the reply notice to their notice, which is dated 26/12/2015.
Reply is when?
So first week of January 2016. By that time,
what is the date?
It is 7th month, 7/1/2016. They had filed the petition on 4/1/2016 itself. No, my lord, the marriage has happened on taken place on 11/6/2015, my lord. 11/6/2015. The first nuptial ceremony has happened on 20/11/2015. 20/11/2015. So subsequently, they started to live together, man, as husband and wife. For my submission, the marriage has been consummated. First submission. The second submission is, my lord, this petitioner wanted the divorce, my lord. Since as per Act is not, there is a embargo that within 1 year you can't file petition. They filed this petition for nullity of the marriage. So kindly come to para 8 of the petition, my lord, which is at inquiry number 30. Sorry, page 21, my lord. Para 8 of the petition before the trial court. So we permit to read this one, my lord.
Yes.
The petition further submits that during her stay at his residence, the respondent on 5/12/2015 has taken to gynecologist Dr. Lata at Pragati Clinic, which is situated at Chikka Alessandra, Bangalore, for consultation. Even to the aforementioned doctor also, the respondent has not allowed her to test and to make preliminary inquiries. The doctor expressed that some counseling is necessary and detailed examination is required from the reputed doctors to test the maturity or otherwise health condition of the respondent. So kindly come to page 30, objection statement which the respondent has filed before the trial court. Para number 11. I may permit to read this particular para. In that one, my lord, there is contrary around after 8 lines in the middle of the paragraph. Contrary to the above, the petitioner had forcibly, by misleading and manhandling the respondent without any intimation to her parents or to anyone, had taken to the said doctor, who is not a gynecologist but is just a physician without any specialization, and the said doctor tried to make physical examination against the wishes of the respondent as regards to her bodily composition or her femininity, and the said doctor forcibly conducted the examination